I want to talk to you a little bit about the bill now. Now, it's 22 sections, 22 pages. I'm not going to be able to go line by line. We just don't have time to do that. But I think the bill does break into kind of three distinct categories, and I want to hit on some high points of the bill and tell you a little bit about what it does. The first section of the bill is a follow-up on an effort that was started 4 years ago dealing with the area of public benefits. Now, 4 years ago, the General Assembly passed Senate Bill 529. It was an effort to eliminate access to public benefits by those ineligible to receive them. We passed several provisions in that bill aimed at getting at that problem. Two of the most important was a requirement that state and local governments that dispense public benefits enroll in the federal SAVE program, and the other is that public works contractors, that agencies that let public works contracts, state or local, at the point of application for a public works contract, they collect a E-Verify affidavit swearing that that company is enrolled in the E-Verify program. The problem with that effort was when that law was passed, there was no enforcement mechanism. There's no penalty in place for failing to enroll in these programs and comply with what's been the law of the state for 4 years now. And what we found through the hearing process is we're not getting uniform compliance. We have a large percentage of governments that have not even enrolled in the SAVE program. That is intended, that provision of the law was intended to protect your citizens, your taxpayers, from bearing the burden of providing publicly funded benefits to those that are by law ineligible to receive them. So we had to come out of this effort with an effective enforcement mechanism. We can't continue to have a law without a way to hold those that violate the law accountable. And what we've come up with is the ability to give citizens, our citizens, to put eyes on their government and bring an action to seek injunctive relief against a government that's not complying with that section of the law. Now, we've continued to hear these wild claims about frivolous lawsuits, and we're sensitive to that. So over the last month, we've worked with local government groups to address the process by which this litigation can be brought to force compliance with these sections of the law. We have drafted into the bill in subsequent revisions a 30-day notice requirement borrowed from the ante-litem provisions in our state code that will give our government, so anybody that wants to bring a claim under this will first have to give their local government or state government, whoever they believe is not complying with these requirements in the code, the opportunity to state with specificity what they believe is the nature of their noncompliance. Then the recipient, whether it be the state government or the local government, will have an opportunity to get into compliance. Now, this isn't a difficult process. Either you're enrolled in the SAVE program or you're not enrolled in the SAVE program. Either you're collecting E-Verify affidavits at the point of public work contracts applications or you're not. So you get that 30 days to demonstrate that you are in compliance with the law. Only then, if they're still not in compliance and there's a good faith basis to go forward, can litigation be brought. We've also provided an additional mechanism if the recipient, the defendant in that lawsuit, still believes this is a meritless claim. We have put a 45-day stop on all discovery activities in the event a motion to dismiss is filed. Now, for the non-lawyers, a motion to dismiss is a motion that's filed very early on in litigation. If you as a defendant believe that what is stated in the claim is meritless, it gives the opportunity to test the sufficiency of the pleadings. And we have provided that a judge must rule on that in 45 days. That is security that any meritless claim will get rooted out without any excessive costs of litigation being run up. Not to mention, we still have the defendants, if there is a meritless lawsuit brought, they still have every sanction that's available in the Civil Practice Act for the bringing of frivolous lawsuits available to them. This is the best solution we could come up with to provide an effective enforcement mechanism to give citizens the ability to put eyes on their government to make sure they're complying with the law that's been the law of this state for 4 years. This isn't a new requirement. This is something that's been required of our government for 4 years. Also in the area of public benefit, we've heard over and over and over again about the disparate number of identifications that are provided to our state and local government for official purposes whenever an identification is required to be presented. We have, borrowing language from other states, are going to beef up what type of identification you can provide to present to your government for official purposes. We're going to ask the Attorney General's office, similar to the way they develop a list every year of public benefits to help enforce the SAVE provisions, to develop a list of what are defined as secure and verifiable identifications. We want to get at those type of documents that we know are most commonly forged. We've heard over and over from the law enforcement community, the FBI even, about how easily forged these matricula consular cards and their rampant use. We want to make sure there is confidence in the identification that's being presented to our government, and we believe this gets at that. Second kind of broad section of the bill is providing new tools to law enforcement. Now, we've heard over and over and over again about the burden being placed on our law enforcement community. And we have provided several new tools aimed at getting at those that are knowingly transporting, harboring, and inducing illegal aliens to come into our state, which ultimately results in our taxpayers footing the bill. Now, we've heard these absurd stories about, well, my church is going to end up getting, my mission group is going to end up getting prosecuted, or the church bus driver is going to get prosecuted. That's patently absurd. We've borrowed this language from federal code. I've challenged people to do this. Nobody's ever been able to show me where a domestic violence clinic or a church bus driver has been prosecuted. But what we have done is we've built in, and I encourage you to read the bill, because a lot of these complaints clearly are grounded in a person that has not read the bill to begin with. But in order to be prosecuted for transporting an illegal alien, first, you have to be proven that you know they're a legal alien. Anybody that's ever dealt in criminal law, that's a tough standard right there, proving knowledge that you know they're an illegal alien. Second, you have to prove that they are committing another crime while doing it. So another predicate act has to be committed. Third, you have to prove that they're doing it for the purpose of furthering their illegal presence in the United States. Now, these provisions exist in federal law to give prosecutors another tool to go at what are called in the media the mules and the coyotes, the people that are profiting. We talked a little bit about trafficking yesterday. This is the type of people that this is intended to go after. There's no examples out there where a church bus driver or a minister who's ministering to his parishioners or providing a social service has been prosecuted under these theories. It's just overheated political rhetoric. It's just not true. And this is going to give our prosecutors the ability to go after folks that are preying on these individuals, bringing them to our state for their own profit, and ultimately to the detriment of our taxpayers. We've also heard a lot about the immigration status check piece of this bill. Everybody keeps jumping up and down saying Arizona copycat, which clearly they haven't read the bill and read what they did out there. But what we have provided in terms of a new tool to law enforcement officers is what we believe a very common sense tool. Right now in Georgia, every time a person is arrested for a felony, they are booked into the jail and their immigration status is checked. That's been the law of our state for several years. We're now going to expand that to misdemeanors. If you're booked in on a misdemeanor, your immigration status is going to check. We are also expanding that to the criminal investigation process. What it says simply is this: if you are a criminal suspect, if an officer has probable cause to believe you've committed another crime, whether it's murder, reckless driving, or anything in between, and you can't provide the law enforcement officer evidence as to your identity. Now, I want you to think about this. When has there ever been a criminal investigation in the history of criminal jurisprudence where a law enforcement officer didn't attempt to determine the identity of the suspect? It's just common sense. It's what happens every day. And what it says, if you can't provide evidence of your identity, we list a whole host of documents, a driver's license, the secure and verifiable IDs that the Attorney General list is going to be developed, or just information as to your identity where the officer can go and independently identify who you are, pull your name down from the DMV database. If you can't do any of that, all we're saying is that the law enforcement officer shall be authorized at that point, as part of the investigation into the suspect's identity, to do an immigration status check. Why wouldn't, in an effort to keep our citizens safe, our community safe, give our law enforcement community every tool possible to identify criminal suspects? It's just common sense. It is a perfectly objective criteria. There is no subjectivity. We don't have the provision there that says you have to have reasonable suspicion to believe they're in the country illegally. It's truly about your ability as a criminal suspect to demonstrate your identity in the context of a criminal investigation.